Mr. Tango.
May it please the court. May I report that I started at 2:05.
You have your allocated.
Thank you very much.
Yeah.
You heard the most extraordinary statement today from counsel for the official opposition, MK. What he said was that the rule of law is worthless, and if I can quote him, that we should throw it into the dustbin. So you have a litigant before you who says that the rule of law is worthless and you should throw it into the dustbin. Well, of course you will do no such thing. Section 1C of the Constitution says that the founding values of the Constitution include the supremacy of the Constitution and the rule of law. So it's not open to a litigant to urge you to throw the rule of law into the dustbin. And then you can understand that it is resentful that freedom under law is here in defense of the rule of law. That is its cause for which it has been constituted, is to defend the rule of law. And we submit with respect that it is ill behoves a litigant who says that you must throw the rule of law into the dustbin to be resentful about the fact that freedom under law is here to do what it was created to do, and that is to defend the rule of law.
Yes, it sounded like an extreme expression to an extent where one would have thought, is it a hyperbole maybe, to try and make a point, but
I don't know what point one makes when you say you must throw the rule of law into the dustbin. And my learned friend mustn't interrupt me now. You can speak when I've done.
Mr. Mpofu,
yes. Well, my lord, I just want to clarify, because I'm now being distorted. I said the rule of law and I equated it to the apartheid rule of law. That must go to the dustbin. That's so I don't want to be misquoted by anyone.
all right. We'll allow you that.
Otherwise, it's yeah.
Yes.
May I turn to
And
the
not
issue?
deliberately as well.
Thank you.
I beg your pardon?
Uh-huh.
Please.
I must not be
Please.
misquoted deliberately.
Please, counsel.
by anybody.
Please, counsel.
Anybody.
Let's hold the decorum. Let's hold the decorum.
May I go to the issue of remedy?
Yes.
Now, on that score, freedom under law is here with a freestanding application of the simplest kind for final relief. It affords the respondents the normal time required by the rules of court to respond, so they weren't in any way restricted in their responses by the time allowed to them. Having launched an application of the most ordinary kind, it is before you today entitled for its case to be adjudicated, and if it makes out a case, for an order to be made in its favor. We submit with respect that if a case is made for final relief, in other words, if it established its cause of action, then it is entitled to an order from this court to that effect. And we say so for three reasons. Firstly, Section 172(1)(a) of the Constitution says that when deciding a constitutional matter within its power, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. And we emphasize a court must declare. And the Constitutional Court has held must to mean must. It did so, for instance, in all pay, as All-Pay Consolidated Investment Holdings v. Chief Executive Officer, South African Social Security Agency, 2014, Volume 1 SA, 604 CC, paragraph 25, where it said the following: once a ground of review under Padja has been established, there is no room for shying away from it. Section 172(1)(a) of the Constitution requires a decision to be declared unlawful. The consequences of the declaration of unlawfulness must then be dealt with in a just and equitable order under Section 172(1)(b). And the court reiterated that in the Nkandla judgment, that's EFF v. Speaker, National Assembly, 2016, Volume 3, SA, 580 CC, paragraph 103. Said declaring law or conduct inconsistent with the Constitution and invalid is plainly an obligatory power vested in the court as borne out by the word must. Unlike the discretionary power to make a declaratory order in terms of Section 38 of the Constitution, this court has no choice but to make a declaratory order where Section 172(1)(a) applies. Section 172(1)(a) impels this court to pronounce on the inconsistency and invalidity, in this case, of the President's conduct and that of the National Assembly. That's the first reason. The second is that freedom under law as a litigant is entitled to an order in its favor. If it comes to court and it makes a case, then it is entitled as of right to an order to that effect, vindicating its claim. But in the third place, we submit with respect that it is also the right thing to do, that the appropriate manner in which a judicial function is to be performed in this case is to resolve the dispute before you, if you can, by a final determination today, rather than an interim order. Then one might say, well, what about the pending matter before the Constitutional Court, the AfriForum matter? Shouldn't the case be postponed pending the outcome of the Constitutional Court application? We submit with respect not, for the following reasons. Firstly, it would be an abdication of the duty imposed on the court by Section 172 and at common law to give a litigant final relief when it makes a case. Secondly, what happens if the Constitutional Court dismisses AfriForum's application and we come back to this court? What happens then? Do we re-argue the case? It just doesn't make sense for us to be required to come back again for reconsideration of our case if we have made a cause of action. But in the third place, what if the Constitutional Court takes on AfriForum's case? Now, with respect, the Constitutional Court has often made it clear how important it is for it, in the performance of its functions, to have the input of the lower courts, the High Court and the SCA, on matters that come before them. So no harm will be done by a judgment from this court, and on the contrary, you will know that you will deliver a judgment which the Constitutional Court has frequently made plain is useful to it in the performance of its function. So we submit with respect that if my client has made a case, then it is entitled to final relief, and that it would not be appropriate to postpone the case. If I could turn to a different topic, and that is the question of the facts of the manner in which the decision was taken in Parliament. My learned friend, Mr. Mpofu, said that somebody lied to you about the process. Well, I don't know whether he included me in that accusation, but what I would remind you of is that I based my submissions to you on the events in Parliament in large measure on the answering affidavit of MK deposed to by its leader, Mr. Zuma. And I invite you to look at his affidavit again, where he makes it absolutely clear that what happened in Parliament was in accordance with the convention that the majority parties endorsed the nomination of the EFF. In his affidavit, from page 06-25, paragraphs 60 to 62, 66, 141, and 142.
Sorry, you said paragraph?
Firstly, paragraph 60 to 62, 66, 141, and 142. I won't read out all of them, but maybe if I could remind you just of 2.5 of them. Paragraph 61. It is common cause that in the Chief Whip's forum, all parties, including the DA, adopted an unwritten rule granting total and undiluted autonomy to political parties in the selection of their own representatives. And then at 141, I admit that no political party represented in the National Assembly, including the DA, contradicted or challenged the established autonomy or prerogative rule or convention which provides that the decision of a nominating opposition party is binding on the National Assembly, nor did any party ever seek to review the said convention. And in the following paragraph, 142, he says, the statement of the ANC Chief Whip is absolutely correct. Now that statement is this, if I can just give you the reference, that statement is quoted by the Speaker at 05-29, paragraph 53. So you have spokespersons for the two majority parties. Both say that we adhere to the convention that the National Assembly endorses the nomination by the minority parties. So you were not lied to, you were quoted the evidence given by MK and supported by the ANC. Can I turn to my learned friend who complains of feeling lonely in his submissions on the exclusive jurisdiction of the Constitutional Court, and I'll try my best to make him feel even more lonely. Under section 167(4)(e), the Constitutional Court has exclusive jurisdiction to determine whether Parliament has failed to fulfill a constitutional obligation. That is what the area definition of exclusivity is. Has it failed to fulfill a constitutional obligation? Now, my learned friend assumes that the constitutional obligation we're talking about is the obligation under 178(1)(h). That's the duty to designate 6 people to the JSC. But it is not our case that the National Assembly has failed to fulfill that obligation. It has designated 6 people. So there's no contention that it has failed to fulfill 178(1)(h). The contention against it is that it has failed to make that designation in accordance with Paja or in accordance with the rule of law, the legality principle in Section 1C. That is the contention. So the constitutional obligation that was violated here was the obligation under Section 3 of the Constitution, read with Paja, or the obligation under Section 1C of the Constitution. But they are stock standard, generic standards which apply to the exercise of all public power. There's nothing exclusive about them. So the fallacy in the contention of my learned friend is that he starts from the wrong premise. We're not here to contend that Parliament failed to fulfill 178(1)H. We are here to contend that Parliament failed to adhere to Paja and to Section 1C of the Constitution. And that distinction was made clear by the Constitutional Court in the case of Women's Legal Centre Trust. The President of the RSA, 2009, Volume 6, SA 94, Constitutional Court, paragraphs 15 to 24. And if I may just read a few extracts from it. Paragraph 15. Justice Cameron said, any exercise of the judicial function may cause tension with the other arms of government and trigger political contention. Hence, the mere fact that a matter is or may become politically fraught does not of itself mean that this court has jurisdiction to deal with it. That will resonate yesterday's argument, where it was said that when there is political sensitivity in the case, then it is one that falls under the constitutional, exclusive jurisdiction of the Constitutional Court. The Constitutional Court held that that is not so. Paragraph 16, Section 167(4)(e) itself contains a significant pointer, its agent-specific focus. The provision means Parliament and the President and them alone. This court has recently observed that the constitutional duties in the provision are pointedly reserved for the actors in question. The wording suggests that the exclusive jurisdiction relates to obligations resting on these agents only, in contradiction to constitutional duties they may bear together with other agents. In other words, if it were a case of a breach of 178(1)H, that would have been in the exclusive jurisdiction of the court. But if it is a case for a breach of a generic obligation of the rules that govern the exercise of all public power, then it is not exclusive. 24. Women's Legal Centre submitted that, on the respondent's own account, the adjudication of the present dispute involved questions that relate to sensitive areas of separation of powers and would require a decision on crucial political questions. That's the argument made to you yesterday. It would therefore fall within 167(4)(e) and this court's exclusive jurisdiction. That was the argument made to it. But Justice Cameron then says, but as indicated earlier, all exercise of judicial power in some way affects the separation of powers and may involve the judicial determination of questions with political overtones. That is not enough for this court's exclusive competency to be engaged. For that reason, we submit that the Constitutional Court clearly does not have exclusive jurisdiction in this case. Then, my last submission. The entire address of my learned friend, Mr. Masuku, and a very large part of the address of my learned friend, Mr. Mpofu, submitted to you that Dr. Hlophe is competent to be a member of the Judicial Service Commission because there are no requirements for membership of that commission under Section to the section we're talking about, other than that he must be a member of Parliament. And so my learned friend Mr. Masuku addressed you at length on how his impeachment as a judge does not disqualify him. My learned friend Mr. Mpofu addressed the same topic. But His Lordship presiding interrupted my learned friend Mr. Masuku and said, "But aren't you straying from the debate before the court?" My learned friend submitted not. We submit with respect that that perspective is entirely misguided, that that is not the debate before court. We did not come here to persuade you that a judge who's been impeached is disqualified from being a member of the JSC. That might be a different debate for another day, but that is not our contention. Our contention did not look at him and submit that he is disqualified. What our case does is to look at the National Assembly and the manner in which it exercised its power of designation. So we look at it top down and not bottom up. And if you look at the manner in which it exercised its power and you test it against the standards to which all exercises of public power must conform, then you see that it was unlawfully exercised. The National Assembly, firstly, didn't exercise a discretion at all. That is already fatal, regardless of what one thinks of Dr. Schlorpe. It secondly allowed itself to simply rubber stamped the nominations made by MK. Another fatal flaw in itself. It thirdly failed to do what Section 165 requires it to do, and that is to promote the integrity and stature of the judiciary in making its appointments. It didn't even ask itself the question whether the nomination of Dr. Schlorpe would satisfy its duties under Section 165. And then my learned friend, Mr. Duplessis, submitted to you that they also exercised that power irrationally and unreasonably. So, the entire perspective of our case is that top-down perspective. Our case is not against Dr. Schlorpe. Our case is against the National Assembly. We say, you, National Assembly, failed to exercise your public power in the public interest. That is why we're here. And that is why we submit that the manner in which you went about this decision was unlawful. As a footnote to it, my learned friend argued yesterday that if this designation is unlawful, then the other 5 designations were also unlawful. Well, that might be, but there's only one designation before you, and the rule established by the SCA in Oudekraal and by the Constitutional Court in Curlin says that a decision, administrative decision, stands and is regarded as valid until reviewed and set aside. So the only decision which has been challenged before you is the one to designate Dr. Schlorpe. The other decisions are not under challenge, and under the Curlin rule are regarded as valid and binding until reviewed and set aside. So that is not your concern, because that is not before you. I thank you for your indulgence.
Thank you, Mr. Tringo.
Thank you, my Lord. I'll be doing the reply on behalf of the Democratic Alliance.
Thank you.
Thank you.
Sorry, just if I may request your indulgence, Mr. Bishop has a broken foot. Could he address you while sitting? Unless he wishes to stay.
Judge, I'm going to try and stand and see how it goes. But if it gets too painful, I might ask the court to
hold him up.
That's not a metaphor for full supporting the DA. We have separate cases. Lord, I'd like to begin with what we submit this case is not about. And I'm going to pick up from where Mr. Trengove ended, which is to say, just as Full's case is not about whether the impeachment of Dr. Hlophe was good or bad, lawful or unlawful, the DA's case is the same. Whether that impeachment was a good decision or a lawful decision is irrelevant to our case. It's irrelevant to our argument of mistake of law, it's irrelevant to our rationality claim, and it's irrelevant to our Section 1654 claim. So it doesn't matter. The arguments you heard from Mr. Masuku this morning do not affect. It may be that in the future Dr. Hlophe wins a challenge to that decision. It's irrelevant to the case we brought. It's the question of whether Dr. Hlophe has repented or not repented is also irrelevant to the DA's case. We don't rely on that. We rely on the fact of his impeachment, which is not disputed. The second thing this case is not about is whether Dr. Hlophe is entitled to be a member of parliament. Again, you heard a lot from Mr. Mpofu and Mr. Masuku about this. Section 19 was called in aid to say what the DA is trying to do here is to interfere with Dr. Hlophe's right to hold public office. This case is not about whether Dr. Hlophe can be an MP. We accept he is an MP. And for the purposes of this case, we don't dispute that. For the same reason, it's not about amending the Constitution. That is an argument advanced by Mr. Mpofu, that effectively what the DA is asking this court to do is to amend the Constitution by imposing restrictions on impeached judges that aren't there expressly. But that is not at all what we're doing. All we're asking the court to do is apply trite, well-worn principles of legality. That a public body must exercise a power given to it itself, and then it must act rationally, and then it must comply with the Constitution. That doesn't require constitutional amendment for this court to apply those principles. Finally, this case has got nothing to do with the privilege of members of parliament, an argument you heard from Mr. Masuku. The privilege of MPs is not affected. They're free to say whatever they like in parliament. That's what the privilege gives them, the privilege to speak without threat of civil or criminal punishment for what they say in parliament. It also doesn't affect the privilege of the National Assembly. We're not saying the National Assembly cannot regulate its own process. We're saying the National Assembly must comply with the law and with the Constitution, which, as I'll get to later, the Constitutional Court has said probably close to a dozen times. The second topic I want to address is the composition of the JSC. And this matters for, first I'm going to address why we submit that the way the JSC is composed matters for assessing the merits of this case. And secondly, I want to address an argument that was made that if the DA is granted its interdict and Dr. Hlophe is prevented from sitting on the JSC in October, that will prevent the JSC from acting because it won't have all its members present. So I want to address that argument. So the first, we heard a lot, and rightly so, about the way in which the JSC is constituted, that it has a diverse representation of judges, lawyers, academics, politicians, and that's part of what gives it its strength. And we agree with that. But I also want to refer the court to authority that the way the JSC is constituted is also vital to ensuring its credibility and its ability to protect the integrity of the judiciary. My learned friends were full yesterday referred you to the passage from the Helen Suzman Foundation case that people designated to the JSC must be suitably qualified. I want to refer you to the case of Hlophe versus Judicial Services Commission. It's the review case. And at paragraph 27, this is what the full court said. The JSC was established and its composition determined by section 178 with the aim of regulating judicial affairs and ensuring the integrity of the judiciary. And then it says at paragraph 47, the substance of section 178 is premised on the recognition that the JSC must enjoy credibility. Moreover, credibility with a nation whose social order is that of a constitutional democracy. And finally, at paragraph 50, if the JSC is to choose persons who can enjoy public credibility as fit for purpose as judges, the JSC had to be constructed to meet democratic norms so that it could make a claim for its own public credibility in a democratic society. So,
what citation was that?
so it's the citation is 2022 3 All SA 87, a decision of the Johannesburg High Court. It's Klopper versus JSC.
Yes, and the paragraphs you
it was 27, 47, and 50.
Thank you.
So what the court is saying is that in order for the JSC to do its job of selecting judges that have credibility, it must have credibility. And so that goes obviously to the general way in which it's constituted, a mix of people from different backgrounds. But we submit also here, to this purpose, when those people who have the power to designate, whether it's the president, the judge's president, the universities, the bar, or parliament, when they are making that choice, they also have to make the choice with that purpose in mind, that the JSC must have public credibility, because otherwise it cannot do its job. And we accept that ordinarily an MP, all things being equal, will be able to satisfy that requirement. But there will be circumstances when an MP serving on the JSC will undermine public credibility. And when that is the case, that person cannot be designated to the JSC. So I then want to deal with the argument that was made that what the interim interdict that the DA and Corruption Watch are asking for would prevent Dr. Klopper from sitting on the JSC until Part B or the Constitutional Court proceedings are resolved. So that may be one sitting, and maybe two sittings, and maybe three sittings. But the argument was made, because the Constitution says there must be 6 members from the National Assembly, if Dr. Klopper is not there, the JSC will not be able to act. So for that reason, the interdict is inappropriate. And there's 2 answers to that. The first answer is that the JSC can act when some of the listed members are not present, if they are absent for reasonable and adequate justifications. And the authority for that is the same judgment I referred you to earlier, the Klopper judgment. And from paragraphs 38 to 44, the court deals with 2 earlier SCA cases dealing with the position of whether the Western Cape Premier had to be part of the JSC, and dealing with a challenge by the Cape Bar to the non-appointment of certain judges. It refers to those cases which dealt with this issue. And from those cases, it draws that principle in paragraph 40, that as long as there are reasonable and adequate reasons for the absence, the JSC can continue. So you can imagine if the JSC, and JSC meetings are called 6 months in advance, they're massive occasions, they last for a week or 2 weeks. If on the way to the JSC meeting, a member unfortunately had an accident and broke their leg and was unable to attend, that wouldn't mean that the JSC cannot sit, because there would be a reasonable and adequate justification for that member's absence, and the JSC would be able to continue. And that's what the full court found in Klopper. And we would submit that an interdict from this court is plainly a justifiable reason. But the second answer is that the National Assembly is free to designate a new person to fill that 6th spot that's currently occupied by Dr. Klopper. And we make that allegation. It's in the papers, in the founding affidavit, paragraph 65, page 1-26. And it's not denied by the Speaker that the National Assembly would be in a position to designate a new MP to take over from Dr. Klopper. So there's 2 easy answers. The interdict would not prevent the JSC from sitting at all, whether the NA acted or not, but the NA can act. I then want to turn to the merits of the review. Now, of course, my case is an interim interdict case, but the prospects of success are relevant. We submit both at the prima facie right level and the balance of convenience level. And there are a few arguments that I want to counter that were made by my learned friends. The first is an argument made particularly by Mr. Masuku that all members of parliament are equal. So if you're an MP, you must be able to sit on the JSC, and nothing else should be required or can be required. And the way we read the Constitution is being an MP is a minimum qualification. You must be an MP in order to be designated by the National Assembly. So if you're not an MP, the NA cannot designate you. But that's not the limits of the requirements the Constitution imposes on how the National Assembly acts. So our case is about how the National Assembly exercises its power to designate. And designate means to choose. You must exercise a discretion. Amongst all 400 MPs, you must choose which ones you're going to send as your representatives to the JSC. And the National Assembly cannot act randomly. It cannot hold a lottery where it pulls 6 names, 3 names from the opposition and 3 names from the non-opposition out of hats. It cannot sell the positions to the highest bidder. And it cannot designate without ever exercising a discretion, and instead leave it to the political parties to do the work that the Constitution assigns to the National Assembly. So in this sense, the case is exactly like the Similani case. There too, Advocate Similani met the minimum qualifications to be the National Director of Public Prosecutions in the NPA Act. He had the necessary legal qualifications. But that wasn't enough. The President also had to act rationally when he took the decision to appoint Mr. Similani. And the same is so here. There was also a submission made that there's no situation in which limits are placed on members of Parliament serving on committees of the National Assembly. And we point out in our heads of argument that that's not true. Under the Intelligence Oversight Act, which creates the Joint Standing Committee on Intelligence, it creates strict requirements for which MPs can serve on that committee. You have to obtain a security clearance, you have to be approved by a committee made up of the chairperson of the NCOP, the Speaker, and the President, and there's a whole process for how you get on that committee. And it's because of the particular work that that committee does. That's an internal committee, it's a parliamentary committee. But because it's doing intelligence work, it requires that we say, even though you're an MP, if you cannot get security clearance, you cannot be on that committee because you will have access to top secret information. And so we're limiting the pool of people who can be on. And we submit, in a similar way, that's the case here. Most MPs, yes, they can be on the JSC if the National Assembly takes a proper decision to designate them. But if that MP, because in this case they're impeached as a judge, if their presence on the JSC would undermine the JSC's credibility, making it impossible for it to do its work, then that person cannot serve on the JSC. An argument was made that because the Constitution imposes consequences for a president who is impeached in Section 89(2) and doesn't say anything for judges, therefore it must be interpreted to mean that there are no consequences for an impeached judge. And we submit, firstly, the argument doesn't really answer the attack, because the attack is that when you designate, you must act lawfully and rationally. So it's not an answer to the attack. But in any event, merely because the Constitution imposes certain restrictions on the President doesn't mean similar restrictions cannot be imposed through other principles of the Constitution, the principle of legality, and Section 1654 of the Constitution. Third, my learned friend Mr. Mpofu made the argument, he emphasized the word consider, and he made the argument that these issues, the impeachment of Dr. Klopper, his suitability, were considered by the NA because they were raised by the various members who debated the issue, and therefore they were considered. That's not our argument, that they failed to consider them in that sense. Our argument is that they didn't consider them because we know from the transcript that particularly the African National Congress said, even though you said all these things about him being impeached, they're irrelevant because we must simply accept the nomination. So that's why they weren't considered. Even they were mentioned. Everybody's aware that Dr. Klopper had been impeached, but they weren't considered because they said we're bound by the practice and we don't have the power to refuse to designate Dr. Klopper. So that's why they weren't considered. Finally, on the merits, there was an argument that the DA was required to attack the practice or convention of accepting parties' nominations. And because we haven't attacked that practice or convention, we cannot complain that it was followed. But that's wrong for two very simple reasons that come from the National Assembly's rules. Rule number 5 says no convention or practice may limit or inhibit any provision of these rules or any order of the House. And you also need to read Rule 9.2, 9 sub 2. Conventions and practices must be consistent with the provisions of the Constitution. These rules, orders of the House, rulings and directives, and guidelines of the Rules Committee. So the conventions and practices are what fills the gap where there's nothing else. But here we have the Constitution. The Constitution says you must exercise the power yourself and not delegate it. The Constitution says you must act rationally, and the Constitution says you must uphold the integrity of the judiciary. So we don't have to challenge the conventions and practices, because on the National Assembly's own rules, rightly so, you could never say a convention overrode the Constitution, but the rules themselves recognize that. I next want to turn to the requirements for interim relief. And there's 4 arguments I need to address here. The first is that granting the relief would violate the National Assembly's authority. There's 2 answers to this. The first is that the National Assembly hasn't opposed the application. So when we cited the Speaker, we don't just cite the Speaker as the Speaker, we cite the Speaker as a representative of the National Assembly. The Speaker is here as the National Assembly. One cannot cite the National Assembly in papers, you always cite the Speaker. So the National Assembly has not opposed this. So in those circumstances, it's difficult to understand how it would violate the National Assembly's authority. And the National Assembly says, we have no difficulty with this order that the DA is seeking. But the second is that the Constitution permits invasion when it is justified. And the authority for that is many cases, but particularly the decision in Doctors for Life at paragraph 38. So in paragraph 37 of Doctors for Life, the court talks about the importance of courts not interfering with parliamentary processes. But then it says in 38, but under our constitutional democracy, the Constitution is the supreme law. It is binding on all branches of government and no less on Parliament. When it exercises its legislative authority, Parliament must act in accordance with and within the limits of the Constitution. And the supremacy of the Constitution requires that the obligations imposed by it must be fulfilled. Courts are required by the Constitution to ensure that all branches of government act within the law. So where Parliament has not acted within the law, it is permissible to grant this type of relief. The second issue on the requirements for interim relief is about OTA. And the argument was made, well, the DA didn't plead the requirements of OTA, and that should be the end of the case. But of course, as the bench knows, one pleads facts, one doesn't plead law. And a useful authority in that is VENMOP 275. The citation is 2016, Volume 1, SA 78, and it's a decision of the Johannesburg High Court. And what the judge there is dealing with, the sort of common refrain you see at the beginning of every affidavit, that legal submissions are made on the advice of my legal representatives. You see that at the beginning of every affidavit. And he says he has problems with this. He says, however impressive this might be to a lay client in justifying a legal representative's fee for voluminous affidavits, I find this practice disturbing in at least 4 respects. First, by their very nature, these submissions have neither evidential content nor probative value. As argumentative, they have no place in affidavits. It is not for nothing that Rule 6.1 of the Uniform Rules of Court provides for an application to be supported by an affidavit as to the facts. He says, secondly, the argumentative submissions that follow expressly admitted hearsay and as such inadmissible. Thirdly, the submissions amount to legal opinions on matters upon which the court is required to decide. So the OTA test is that this is the clearest of cases. Various other words are used. But that's not a fact. That's an opinion you draw from the facts. Is this the clearest of cases? It's not so just because a deponent says this is the clearest of cases. The question is, have they pleaded facts that show this is the clearest of cases? So I, of course, accept that the DA is bound to the facts that are in the founding affidavit. But the fact that it didn't in the affidavit say, these facts mean this is the clearest of cases, there's no reason to dismiss the application.
And does Sitlohelo, or rather OTA, create new requirements other than in Sitlohelo?
In our view, it doesn't create a new requirement. What it says is when the court is dealing with interdicts, of organs of state or the exercise of public power, it must be particularly careful when it grants it. So when it's weighing the balance of convenience, it's really, it comes in at the balance of convenience stage, that the balance of convenience will only favor the grant of that interdict against an organ of state in the clearest of cases because of the separations of power harm. But I've never understood it as a new, separate, self-standing requirement.
It's an elaboration or
Yes.
clarification.
Yes, it's about how one of those requirements applies in a particular subcategory of cases.
Yeah.
We come home whether OTA applies or not, but it's debatable whether it does for two reasons. Firstly, our interdict is against Dr. Klope, not against the National Assembly, and secondly, the National Assembly and the JSC have abided. The next point on interim relief is about the prima facie right. And the argument that was made here is that prospects of success in a review cannot establish a prima facie right. We've dealt with this in paragraph 43 of our heads, that there's subsequent constitutional court authority that qualifies what Moseneke DCJ said in paragraph 50 of OTA. It's the South African Informal Traders case and the Vaal River case. And what they say in Informal Traders at paragraph 25 is, a prima facie right may be established by demonstrating prospects of success in the review. Could not be clearer. But in any event, we identify other rights. We identify our right to an effective remedy, and we refer the court in paragraph 44.1 to the authorities that say that is that can be a prima facie right for the purpose of interim relief. And we rely on the right to an independent and impartial judiciary. And we refer in paragraph 44.2 to the sources of that right. Section 34 of the Constitution, Section 1654 of the Constitution. And we didn't have to plead that. We pleaded the right expressly in the founding affidavit. We don't have to explain the legal source for the right that we're pleading. The opponents don't have to plead case law when they're asserting where the right comes from. That is legal argument, properly in heads. So there clearly is a prima facie right. On the question of alternative remedies, the argument was made that in their answering affidavit, MK listed a variety of alternative remedies. We didn't deal with it in reply, and therefore they must be accepted that there are alternative remedies. We do deal with it in the reply. It's paragraph 46, case lines 08-17, where we say we deny any of these are alternative remedies. And they're obviously not when you look at them, because the one is to amend the Constitution. But an alternative remedy for the purpose of interim relief cannot be, well, you could change the law. Yes, that's always the case. We could change the law, and then maybe we wouldn't need interim relief. But that's not a reason, that's not an alternative remedy. An alternative remedy is an alternative remedy under the existing law, where I could go to court. Could I get damages? Could I get some other type of legal remedy that would avoid the need for an interdict? And as Justice Collis pointed out, these could never be obtained before the 7th of October. You could never amend the Constitution before the 7th of October. You almost certainly couldn't amend the NA rules before the 7th of October. Those processes would take far longer. There's also an argument that, well, our alternative remedy is we should have interdicted Parliament or MK. But, I mean, there's three parties, Parliament, Klope, and MK. We come to court and we ask for an interdict against Klope. And then the argument is, well, you could have asked for an interdict against the MK. But the answer then, if you'd asked for an interdict against MK, is, well, you could have asked for an interdict against Klope. It doesn't get you anywhere. We've asked for an interdict against Klope. Saying we could have also got an interdict against somebody else is no reason not to grant it against Dr. Klope. And finally, on the final alternative remedy proposed is that we could have sent a letter of demand. In our replying affidavit at paragraph 46.2, we invite Dr. Klope to concede to the relief and agree not to attend the JSC sittings in 7th of October and to treat the request in the replying affidavit as a letter of demand. We haven't yet received a response to that. Lord, I was going to deal with this issue of the abuse of process, but I was largely going to deal with what Mr. Trengo began his address with, about the rule of law. So I'm not going to repeat what he said, but just to emphasize the fundamental importance of the rule of law. and it's not something that can be discarded. I then want to, my learned friends, Mr. Mpofu didn't deal with the issue of standing, which is raised in their heads quite extensively. I don't want to deal with it in any detail, but can I just give the court one reference on the standing issue? And the case is Democratic Alliance versus Acting National Director of Public Prosecutions. It's one of the first of the so-called spy tapes cases. It's 2012, Volume 3, SA 486, SCA, in which the Justice Navsa for the Supreme Court of Appeal overturned a decision of the High Court saying that the Democratic Alliance lacked locus standi to review a decision to drop charges against then President Zuma. And it said the Democratic Alliance is entitled to act in the public interest, supporting the rule of law, because that's one of its. And exactly the same applies here. If I can then turn to the issue of jurisdiction, and just to outline the DA's position up front, we say that the Court does not have exclusive jurisdiction for Part B. This court has jurisdiction for Part B. But even if we're wrong about that, even if the Constitutional Court has exclusive jurisdiction for Part B, this court still has jurisdiction to grant the Part A relief. And it's not necessary to decide the issue of exclusive jurisdiction in order to grant the interim relief. On the first question of whether for the Part B relief and for Full's case, for final relief, the Constitutional Court has exclusive jurisdiction, I endorse what Mr. Trengove said, but I just want to refer the court to one other case that may make Mr. Katz feel even lonelier, because not only does everybody here disagree with him, Mr. Katz 2 years ago disagrees with Mr. Katz today. So in the African Transformation Movement case, which Mr. Katz referred to quite rightly, he drew to this court's attention, because in that case the ATM, who's also his client today, took the opposite approach. It said that, and the speaker in that case said that the issue was in the exclusive jurisdiction, and Mr. Katz argued that it was not. And this is what the court said. It's at paragraphs 22 and 23. It's in our bundle. This passage starts at page 243. The judge said, "In my judgment, the cause for complaint by the applicant is procedural in nature. It is abundantly clear that the applicant's case is not that Parliament or the President has failed to fulfill a constitutional obligation, as envisaged in section 1674E. It is the procedure leading to that end that is impugned, a means to an end. To suggest otherwise would be tantamount to putting the cart before the horse." Then says, it could hardly be suggested that when the Speaker commits an alleged irregularity, as was argued by Mr. Katz, in deciding how Parliament is to conduct proceedings in a motion of no confidence in the President, that such a decision amounts to Parliament having failed to fulfill a constitutional obligation. It cannot be suggested that when the Speaker acts irrationally or in an unreasonable manner in the exercise of her discretion in deciding on the voting procedures, such decision amounts to Parliament having failed to fulfill its constitutional obligation. And so exactly the same is here. Same is true here. Although it's not the Speaker, it's the National Assembly, our case is that they failed to exercise their discretion and they acted irrationally. That's the case we brought. It may be that there's another case that could have been brought that says that the designation of Dr. Klope is a failure to fulfill the obligation in section 178(1)H. That's a case that AfriForum makes in the Constitutional Court, but it's never been our case. And our case is in this court's jurisdiction. Finally, on the question of whether this court has jurisdiction to consider the interim relief, I understood Mr. Katz to largely concede that, to say that, yes, this court probably does have jurisdiction. Even if the Court has jurisdiction for Part B, this court still has Part A jurisdiction. But he said it would only be appropriate to grant it in the circumstances set out in paragraph 32 of the UDM case. So just a few submissions on that. We submit that it's very different. The UDM case was about suspending the operation of a constitutional amendment. What we're dealing with here is something far less drastic. It's merely interdicting one person from serving on the JSC. So we're not sure that those strict requirements apply. But even if they do, even if the strict requirements in paragraph 32 of UDM apply, they're met in this case for all the reasons that are given in the founding affidavit. The final point, just to emphasize, is if this court wants to grant Fulls final relief, it must make a final determination on the exclusive jurisdiction question, because it cannot grant the final relief without deciding that it has jurisdiction. For this court to grant the interim relief, it does not have to decide that question. It can merely decide that whether or not Part B is in the exclusive jurisdiction of the Con Court, it would have jurisdiction for Part A. So even if Part B is an exclusive jurisdiction, it has jurisdiction for Part A. So it can leave that issue undecided if it wishes to. And that leads me to the final topic I wish to address, which is the question of should the court grant interim relief or final relief or both? How should it deal with the fact that it has applications for both before it? Firstly, to clear up some confusion about the order that we want. There was some paper moving around and uncertainty about the order. We uploaded the correct order exactly as we wanted onto case lines. And so it's in substance identical to the order sought in the notice of motion. The only difference is to accommodate the new constitutional court proceedings, which didn't exist when we launched the application. And so what it says is the interim relief would be pending either the determination of Part B in this court or the determination of either the DA full corruption watch application or the Adv Forum application by the Constitutional Court. Because obviously once either of those applications are determined on the merits, the interim relief should fall away. And so we're just trying to accommodate what's happened subsequent to the launching of the application.
But are there two Constitutional Court application numbers?
Yes. Initially, the paper we gave you only has one.
Well,
I think
it refers to CC2253/24 and or case CC2253 of 24, exactly the same.
the new one we've uploaded on case lines has got different ones. I think it's
223 or something.
It's 222 is the Adv Forum one, 222 is the Adv Forum one, and 253 is the joint application by the three applicants here.
Where is it uploaded? Just give us a close reference, please.
So,
Where on page lines is it uploaded?
I'll get it in a second, the section lady, I apologize. So that's the interim relief that we want, and we want our interim relief. We're agnostic about whether you also grant full their final relief or not, as long as we get our interim relief. So the case lines reference, my lady, is 21-1.
Thank you.
And my leader, Mr. Jamie, referred you yesterday to the ZEP case as an example where you can grant both the final and the interim relief. But what this court should not do, we submit, is to grant the final relief and not grant the interim relief. Just as Full has come with an application, the DA has come with an application. The DA came to court before Full did. We were the first applicant to launch our litigation. And we're entitled to determination of our application. And we submit there is a reason why interim relief is important, whether final relief is also granted or not, which is we want to protect the October interviews for the JSC. And if interim relief is granted and there is an appeal on that order, the appeal will not suspend the operation of the order. If only final relief is granted and there is an appeal of that final order, the appeal will suspend the operation of the order and will defeat the purpose for which the DA came to court, which is to prevent Dr. Klopek going to the October interviews.
Unless the argument is that the kind of relief then is actually final relief.
Well, Lord,
What Mr. Mpofu, Mr. Masuku said. Sorry.
Lord, that may be a debate that has to be had later, but I think it's plain the interim relief.
I follow what you say, but
yes.
There's a difference of opinion.
There may be, and depending on what this court says in its judgment, it may be a dispute that will need to be resolved. But we still submit that the interim relief, if this court makes it clear that its relief is interim in nature and not final in effect, then there will be no debate. And how Section 18 of the Superior Courts Act operates will be clear, and there won't be another need to. I was recently involved in a matter where exactly that had to happen. Apparently interim relief was granted, and the parties then had to go back to court to fight about whether it was interim or final. So I prefer to avoid that. So we submit that ideally what this court can do is grant both. If the court's not inclined to grant both, we submit that it has an option to grant the interim relief, but not at this point to decide Full's application for final relief. So I accept completely what Mr. Trengove submitted to this court, which is they brought an application, and the application must be decided. But this court can decide when it determines the application. It has the power to hold a decision in abeyance, to reserve judgment, pending the outcome of other litigation. And if I can give the court the references for that proposition. The first is the Masuku case. It's 2022, volume 4, SA 1, CC, and it's at paragraph 133. What happened there is the Masuku case was about hate speech. And the case was heard, and then shortly after, the Constitutional Court heard the case of Kolani, which was a challenge to the constitutionality of Section 10 of the Equality Act. And the court said, I'm going to hold in abeyance my judgment in Masuku until I've decided Kolani, because Masuku must be decided on the basis of the outcome of the challenge to Section 10 of the Equality Act. So it says, we held it in abeyance. And you'll see 3 years passes between the hearing and the judgment. The second case is Mokone versus Tassos Properties, 2017, volume 5, SA 456 CC, at paragraphs 67 and 68. So what happened there briefly is there were 2 appeals before the Constitutional Court. The one was an appeal by a lessee about whether they had a right of preemption to buy the property they were leasing. The second was an eviction, an appeal against a grant of an eviction from the same property. But what the court did is it upheld the preemption appeal and sent it back to the High Court because only part of it had come up on appeal. There were still other parts of the action that had to be determined. So it upheld the one appeal and then said, I'm holding the other appeal in abeyance until the determination of that outcome in the High Court. And the court expressly said it has the power to do so. It quotes Section 173 of the Constitution and says, put simply, this says, the mentioned courts may regulate their own process, taking into account the interests of justice. I will say nothing about equity, but based on this, I do not see why proceedings may not be stayed on grounds dictated by interests of justice. Whatever the import of what was said by courts previously may be, the Constitution lays down its own test, and it has everything to do with the interests of justice. In this context, the idea of interests of justice is quite wide. I will not attempt to delineate what it encompasses. Suffice to say, what justice requires will depend on the circumstances of each case. So this is a very similar situation where the court may take the view, and I'm not advocating for it. All I'm saying is don't refuse to grant our interim relief. One option open to the court is to grant the interim relief and then say full application is held in abeyance to be determined together with Part B of the DA and the Corruption Watch applications, or held in abeyance pending the outcome of the Constitutional Court proceedings. This court has the power to do that.
But their argument is that they've argued it already.
They're entitled to a judgment. They're not entitled to a judgment today.
Yeah, but that's what they're saying.
Yes,
They've
and
argued the matter already. They don't come back on a different day.
Yes.
Come and argue the very same thing they've argued.
But that was the case in Masuku, and that was the case in Mokone. The cases were argued, and they said even though your appeal has been argued, we're holding it in abeyance until the outcome of other litigation, because it would not be in the interest of justice to decide this case until that case has been decided. So this court has the power to do that. Finally, just 2 very quick submissions on costs. The first was a submission that Dr. Klope should get costs even if he loses. I think the submission was primarily addressed at freedom under law and certain allegations that were made by the opponent to their affidavit. If one looks at the DA's papers, there are not similar scurrilous allegations about Dr. Klope in those papers. What's said is factual, he was impeached, and so that type of submission doesn't apply to the DA. The second submission is just that BioWatch is irrelevant to costs in this case. Everybody before you is a private party, except the National Assembly who is abiding, and the applicants have all agreed not to seek costs against the National Assembly. Everybody else, the DA, Corruption Watch Full, Dr. Klope, and MK are all private parties. And so the traditional BioWatch rule that often comes into constitutional litigation doesn't apply here. And we persist with our request for costs on a punitive scale against Dr. Klope and MK. Those are my submissions.
Thank you, Mr. Bishop.
Lord, Mr. Bishop asked if he could steal some of my time, and I graciously accepted that proposition because I'll be quite short. I've got 6 matters to deal with in reply briefly. The first 3 are more procedural and the last 3 are more substantive. So just on the question of remedy, we haven't uploaded a draft order, but we think that the proposition or the proposal made by the DA is a good one, that the interim relief, if it were to be granted, should be pending either the Constitutional Court decision in those 2 applications or Part B in this one. We'll upload a similar order when we're done, and we'll make sure that your registrars have it. The second topic and the third topic are related, and it's the question of abuse and the question of costs. The argument on abuse is it's wide-ranging. The attack is to say we've come, I think they said we hunt in packs, we've come in separate applications and wasted their time and money. But what I want to say is what one should really look at first is the question of standing. Corruption Watch's standing was disputed. The Corruption Watch went to great effort to explain why it's here. Ms. Maharaj Pillay gave extensive submissions yesterday about it. And this wasn't addressed, as far as we could see today, about Corruption Watch at all. We heard about how Full and the DA are worse than us, the DA because it's a political party and Full because of the history. But we weren't told why our submissions on standing on Corruption Watch were wrong. We've also explained why we came in a separate application. It's in the replying affidavit. I don't need to take the court there, but just a note. It's at bundle 10, page 24. And what we really say is that we can't go with the DA because we aren't a political party or an NGO. And we say we can't go with Full because we think interim relief is the way to go. That's the way we approach the case. Hence we brought our own case. And we also say we aren't an amicus because, in a sense, we are partisan because we want relief. We aren't just here to assist the court. We are an applicant. If we'd come as an amicus and made the point, we would no doubtedly have been told we are partisan and you shouldn't have come as an amicus. What's not addressed is that all the respondents had a full opportunity to address our papers and did so. They filed consolidated affidavits, the 2 interim application matters, which are lengthy and deal with the applications for interim relief. So there really isn't a question of prejudice. So what we have left is really scandalous allegations about who Corruption Watch is and who funds it, etc. But these are comprehensively addressed in the replying affidavit. And we didn't hear anything today to dislodge those cogent explanations. As to costs, I mean, we don't care about costs, we hear about principle. If Corruption Watch wins, we leave that issue in the court's discretion. It's to do with costs. But if Corruption Watch loses for whatever reason, we say this. There were many unfounded allegations made against our client. In answering affidavits, they were then repeated in heads of argument, and they were repeated today. And we say that if Corruption Watch loses the application for interim relief, those unfounded allegations would factor into the court's determination of a costs order, and that the court wouldn't grant costs in favour of the respondents who made those allegations against our client.
Yes.
So the next topic is just about alternative remedies. We were told today that Corruption Watch didn't address it. Corruption Watch addressed it. In paragraph 69 of the replying affidavit, we address it in full. That's at case lines page 10, stroke 21. My last 2 topics are a bit more substantive. The first one is about the right we assert, and the second one is the question of harm. So on the question of right, we've heard a lot about the outer test, and the outer test apparently now gives us 8 requirements for an interim interdict. But what paragraph 45 of outer says, the Deputy Chief Justice Moseneki says, it's unnecessary to fashion a new test for the grant of an interim interdict. Of course, what he says, though, is that when you're doing, Mr. Bishop made the point, when you're asking to restrain public power, there are further considerations that play a role. Clearest of cases, in the balance of convenience because of separation of powers. But the court didn't go out and invent an entirely new test. It modified and adapted the old law that's been around forever. So the question is, what did we plead? And you were taken in the MK party's argument to one part of the founding affidavit, the heading about a prima facie right. And it's correct. Under that heading, we say we assert the right to review. But that's not the entire founding affidavit. If one turns over the page, we don't need to go there, but it's page 0331, paragraphs 94 and 95. Corruption Watch pleads what it says will be irreparably harmed in the interim. And it refers back to earlier parts in the founding affidavit where what is said is what I said to the court yesterday. What will be irreparably harmed is the independent, effective judiciary. Now we repeat this in the replying affidavit. And again, we were told that Corruption Watch did not respond to paragraph 164 of MK's answering affidavit. But that's incorrect, because it's exactly what we responded to, and we referred to para 164. So that starts at paragraph 55 of the reply at 10:17. But the specific point where we bring it together to make it clear about what rights are being affected is at 10:20 at paragraph 65. Justice Collis said, what about section 34 earlier? And that's what I mentioned yesterday. It's not in the affidavits. I'm not going to say it is. But we've heard about what law needs to be pleaded and where the facts need to be pleaded. But the point I made yesterday was that the corollary of an independent judiciary that must be given effect to and protected by organs of state in section 165 is the section 34 right. And that was my submission. My last topic, and I won't be long, is the question of harm. And what we heard yesterday and today from Mr. Masuku, Mr. Masuku and Mr. Katz yesterday, but from Mr. Masuku and Mr. Katz, was that the past is irrelevant. They both said the fact of the impeachment is irrelevant. And our proposition is that this isn't actually the past. This is right now. Dr. Hlophe was removed for conduct that happened a long time ago, 2008. I mean, I'm quite young. I was still in high school in 2008, if that means anything to anyone, before I even entered law school. But when was he removed? This year, in February. This isn't the past, it's the present. And again, just to draw us back to what actually happened, Ms. Maharaj Pillay made this point yesterday. This isn't examples about other people, Mr. Mpofu, my learned friend, spoke about who gets convicted and sent to jail for 20 years can become an MP. That's not what we're speaking about. Justice Hlophe was found guilty of attempting to influence constitutional court judges to find in favor of Mr. Zuma. Something Ms. Maharaj Pillay said yesterday was that this first thing Dr. Hlophe does when he's removed as a judge is join Mr. Zuma's political party. No one's denied that or addressed it. And why this is still today relevant is because before this court, and in an argument that was made today, Dr. Hlophe still refuses to appreciate the gravity of his misconduct. and the impact that this can have on the independence and the perception of the independence of the judiciary. And we say that this demonstrates the undoubted appreciation of serious harm that Corruption Watch has proven and entitles us to interim relief. Those are our submissions.
Yes. Thank you, Mr. DP. That's it. Well, that brings us to the tail end of our proceedings, and it remains for us to thank all participants, in particular counsel, in their extensive submissions and heads of argument, and judgment will be handed down in due course.